and Mr. Rivera are not here at this time. And,
Attorney Aubert is here. He's just not in the room at the time. And Attorney Birdsall will be joining us a little later.
okay. And are you ready to roll?
Judge, counsel has shared with us the outline of some of the witnesses. I wanted to briefly describe one witness that I suggest may be irrelevant and ask the court to consider relevance before that person takes the stand, and then we are ready to go. So I want to make a very short argument and then proceed. That witness is Caitlin Ryan. She is the landlord of Rosario Gutierrez. What's been represented to me off the record is that what is about to be solicited is that Mr. Gutierrez was behind in his rent and faced eviction shortly before, or was going to face eviction shortly after the date of his of this incident. I'm going to suggest to the court that whether you are in good graces with your landlord and face eviction is irrelevant for this case, and so that's the end of my argument.
And this would just be going towards the police's lack of investigation into Mr. Gutierrez's financial situation. That's the extent of it.
That's very, very speculative that checking on the status of his rent would lead to anything the jury could use in deciding on the case. What am I missing?
There's been testimony about Mr. Gutierrez's finances, that his mother assisted in providing him funds to go towards bills, rent, things of that nature. There's also been testimony that Mr. Gutierrez was behind. I think this came in with Detective Correa, that he was behind. He had several delinquencies on his TransUnion account. And so this is just furthering going that he was in a financial hardship position, which then gives credence to the fact that law enforcement should have looked into people that he owed money to. Like I said, I don't have anything further about the relevancy of the testimony.
It's the objection is sustained.
Okay.
Okay.
Then there are a couple of developments that occurred as far as witness availability. The defense had intended on calling Detective Anschutz back to the stand to establish prior inconsistencies. We were informed that the detective went out of state and is not available to come testify today. So the state and myself will hopefully be reaching some sort of stipulation as far as it relates to those prior inconsistencies. So I'm hoping to have something drafted up and ready to be read in by this afternoon, something that addresses both what the state and the defense would have wanted to come from that witness. Also, Officer Morrissey has been very ill, and so there might be a stipulation as far as his testimony as well. So, yeah, just wanted to kind of give the lay of the land to the court.
Okay. Many weeks ago, my wife set up a medical appointment for tomorrow at 12:45. That at that time,
Sorry, Judge, I can barely hear you.
at that time, did not appear it was going to collide with a 2-week case that's in its 4th week. So I didn't see any conflict. It's at 12:45 tomorrow, and so I probably will break about around noon, and we'll be gone for about 2 hours. And we'll start again at 2, just so you know. They're going to lose a little bit of time tomorrow, and probably timing is terrible, but that's what's going to happen tomorrow.
2 hours from the appointment, or you'd be back around?
No, I don't think it's a long appointment, so
Okay.
I would hope to be back by 2.
Very good.
Leave at 12 and be back at 2.
Thank you.
Okay. Anything else?
Not from the state.
Not from the defense, Judge.
On the first day of spring, and also now that the college basketball season is over, well, I think you are paying close attention.
I thought the NIT tournament was still going.
Well, anyway, we're ready for baseball, and we're ready to continue the case. So, Ms. Muller.
Thank you, Judge. The defense would call Sergeant Daniel Bandi to the stand.
I do solemnly swear that testimony you're going to give in this matter will be the truth, the whole truth, and nothing but the truth. So,
Yes, I do.
please be seated.
Good morning, Sergeant. If you could just spell and state your name for medical reporter.
My name is Daniel Bandi, B-A-N-D-I.
And how are you currently employed?
I'm a sergeant with the City of Kenosha Police Department.
How long have you been in that occupation?
I've been a police officer for, I think, 28, going on 29 years. I've been with the City of Kenosha for the last 16.
And as a sergeant, how many years have you been employed in that position?
I believe 7.
Just jumping right to it, do you remember doing case in do you remember doing work in the investigation of the disappearance of Mr. Rosario Gutierrez?
I was involved in that case as a supervisor, yes.
And can you explain to the jury what a supervisory role is like in this type of investigation?
Generally, as a supervisor in specific, I'm assigned to the Detective Bureau, and basically I advocate for the detectives if they need supplies or if they need additional personnel, that sort of thing. I also inform our administration what's going on, explain to them the situation, keep them updated. That's my basic role. Occasionally I jump in and we'll talk to people or fill in where detectives might need a hand. In this particular case, what I did is a brief canvas of the apartment complex, talking to other people that were in the complex briefly to see if other detectives needed to go take statements from them or to follow up and speak with people that live there.
Okay, as far as your canvassing of other residents on the property, do you remember who you spoke to?
Specifically by name, no, I do not.
Did you speak to an individual named Jennifer Ziegler?
I believe that I did. It sounds familiar.
How about Nathan Hensley?
I believe so.
In addition to you canvassing individuals who lived at Wood Creek apartment, you also were overseeing other things that were occurring.
Yes, that's correct.
One of which the drone usage that Kenosha Police Department used to do an aerial search of the area west of Mr. Gutierrez's apartment.
I requested that the drone from the Sheriff's Department. The Sheriff's Department had the drone program at the time. They still do. I requested that they come out. I was not overseeing the operation of that, though. I'm not a licensed. I don't use that.
And why did you make that request?
The request was made very simply because it's an efficient way to search a large area rather quickly.
And did you ask that any foot searches be done of the surrounding area around Mr. Gutierrez's apartment?
I don't remember. I probably did, but I don't remember if I did. And I don't think I specifically named that in my report.
To your knowledge, after the drone was used to conduct the aerial search, was there any information gathered from that helped in the investigation?
From what I remember about the drone search is that there was nothing found in the area that was searched. So in that respect of nothing being found, that was important in the investigation, yes.
And that was just the area west, that wooded area west of Mr. Gutierrez's apartment.
Yes, that's correct.
That there are other wooded areas around that area. To your knowledge, were those searched?
I don't remember.
Do you remember overseeing around May 21st, 2022, the pumping of the septic tank on Mr. Anderson's property?
Yes, I do.
And why did you, as a sergeant and overseeing this investigation, ask that that be done?
That the septic tank was pumped. That is a place that you could hide a body, and the tank had liquid in it, and so we wanted to look and see.
And did you find anything?
We did not.
Did you also ask, or did you ask about anything be done as far as the dumpsters on Mr. Anderson's property?
I don't know if I specifically asked about it, but I do remember that there was a dumpster on the property, and we ended up, I believe, emptying it out and looking through it.
And why did you want to empty it out and look through it?
See what was in there?
And you didn't find anything?
Nothing of evidentiary value in this case.
When you say evidentiary value, what do you mean by that?
There was trash that was in there, so the broad topic of, is there anything in the dumpster? Yes, there were items in the dumpster, but there was nothing that I remember that was like bloody or, if there was body parts or a gun or drugs or anything that would be illegal or that was pertinent to this case that I remember.
I have nothing further for Sergeant Bandi, subject to redirect.
State?
Sergeant Bandi, you were asked about drone search of a wooded area as well as whether other wooded areas in the sort of general vicinity of Wood Creek Apartments were searched. Since May of 2020, have any human remains been found in any of the wooded areas that would be covered in those questions, which you thought would cause one to need to compare it to Rosario Gutierrez?
Not that I'm aware of.
Okay, and you would be aware of that, correct? As a sergeant at the Kenosha Police Department, if human remains had been found in any of those areas, you would know that.
That's correct.
Okay. And you were asked about the contents of a dumpster at the Anderson, at the Mequon address of the defendant. When you indicated nothing had been found, was any carpet that had been cut out of that minivan on the property, was that found in the dumpster?
I don't believe so.
Okay. And were any clothing found in the dumpster, such as a blue checked plaid shirt or any of those kind of things?
No.
I have no further questions.
Any redirect?
Yes. Yes, thank you. Briefly, the state had just asked you about whether any remains have popped up in the area surrounding Mr. Gutierrez's apartment since May of 2020. However, since, let's say, May of 2020, have Kenosha Police Department or any law enforcement agencies, to your knowledge, continued to do any active searches for Mr. Gutierrez?
Yes.
And when was that?
Since the original incident, I don't know the exact dates.
So, but nothing this year in 2023?
Not that I remember.
And nothing in late of 2022?
Again, I don't remember the exact dates, but it's not in my report. And, part of my function is to support the detectives. The detectives do a lot of the actual searching, and so I may or may not accompany them. So if, for example, if we were going to go out of county and do a search at a particular location, I would arrange for resources from that particular county, whether it's a fire department or a police department, whatever it might be. The specific dates, I don't remember.
And that's fine. And I guess what I'm trying to ask is, it's not as if every week there's a search party that goes out.
That would be fair.
And the additional searches that had occurred were closer to the May 19th, 2020 date.
I guess you have to be more specific in searching of where.
Sure. So were you aware of the searches that occurred near Harrington State Park?
Yes, I was.
So that was an additional search that occurred?
Yes, it is.
And that, to your knowledge, did that yield any evidence?
I was not let me back up. I was not physically at that search. And as far as I know, there was no evidentiary value or anything of evidence that was recovered during that search.
And then there was the search of the Greenview/Anderson Tree Farm.
Correct.
So that would have, in your knowledge, that was a subsequent search that was done.
There were searches done at the Anderson Tree Farm. That is correct.
And at Mr. Anderson's residence.
Yes.
And at the residence of Susan Brown Williamson.
I'm not sure I know who that is. If that's the Cedar Beach Road address, then yes.
But to your knowledge, I guess what I'm going back to is that outside of those searches that were completed by Kenosha Police Department, if you know, there weren't any additional searches that were done in the Kenosha area.
Well, there were searches of electronics. I don't think that's necessarily what you're asking. As far as the physical searches, I don't remember any. Detectives may have gone out and searched without notifying me. But again, that's a specific question to a specific detective that I can't answer.
Nothing further, Judge.
Nothing on that.
You may step down.
Thank you.
Call Officer Luke Courtier to the stand.
Do you solemnly swear the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth? So help you God. Please be seated.
Good morning, Officer. If you could be so kind just to state and spell your name for Madam Court Reporter.
Okay, Officer Luke, L-U-K-E, last name is Courtier, C-O-U-R-T-I-E-R.
And where are you currently employed?
The City of Kenosha Police Department.
And how long have you been employed with the police department?
Approximately 7 years.
In your term of employment with the Kenosha Police Department, do you remember working on a case involving Mr. Zachariah Anderson?
I do.
And how involved was your involvement in that case?
I had a small part in it. Very small part.
And what was your small part, if you remember?
I was asked by Detective Kenosha to respond to the Kenosha County Jail and retrieve Mr. Anderson's clothing.
Okay. The clothes that you examined, were these the clothes that Mr. Anderson was wearing when he was arrested?
I'm not sure.
You examined them though, correct?
Correct. Yes.
Okay. Judge, I do have exhibits that I would like the officer to open. I was informed that Detective Correa had taken the scissors. I don't know if we have another pair of scissors.
You are pretty good bag, will you?
I will.
And defense exhibit 299 to the witness.
Update extra large. If you have large, yeah, that's okay. Right.
And if you don't mind just opening that, that exhibit.
Okay.
Thank you.
I'm gonna remove them.
Yes, please. Can you explain what that exhibit appears to be?
This is a V-cut white T-shirt, size large, with a George brand.
And is that the T-shirt that you had previously inspected?
Yes, it is.
And when you examined it, did you observe any stains or anything of that nature?
Yes, I did. I noticed a very small stain on that would be the back right side of the shirt. It's like a light orange brown stain right here.
Was there anything else that you noticed about the shirt?
Not that I noticed, no. Well, I guess other than the fact that it appeared new. Basing that on the fact that the imprinted tag on the back of the collar is not faded at all.
And do you remember making a observation or determination about the brand of that T-shirt?
I do. I believe it was probably via a Google search, revealed that this brand George is commonly sold at Walmart stores.
Walmart?
Correct.
And then were there any other things that indicated prior use, such as sweat stains or any other stains that you had noted?
Not that I noted at the time. No.
How about now? Do there appear to be any, what appears to be sweat stains?
Yeah, there looks like there's like some yellowing on the bottom of the armpit area. That would be common with sweat stains.
You can put that exhibit back in the bag. Thank you, officer. And I'm going to hand you what's been marked as Defense Exhibit 300. And I'd ask that you do the same with opening it. Yeah. Yep.
Almost there. Okay.
Thank you. Yes, if you don't mind opening it. Yeah, thank you. Okay, and now are these the jeans that you previously inspected?
Yes, they are.
And when you inspected them, did you make an observation about the brand?
Yes, I did. I noted that it's Levi Strauss company brand. Size 34 wide, 32 long.
And did you make any conclusions or do any further, I guess, investigating into where those jeans can be purchased?
Again, the same way I did the t-shirts, quick Google search revealed that they're commonly sold by Walmart stores.
Thank you.
Okay.
Handing the witness the mark of defense exhibit 319.
I'm going to go ahead and open this one.
Yeah. Can you tell us about those flip-flops?
So these are the flip-flops that I examined during that day. Some of the things that I noticed, I'll say in addition to the colors, was that they appeared very worn based on the fact that there's the foot impressions. You can make out each individual toe. So they appear to be frequently worn. The other thing that I noted was the two different sizes. This is the right shoe here. Noted that it's size 11, and then the left shoe is size 12.
And did you notice anything about the brand?
I did, just based on the logo of it. I don't think it had a actually written brand name, but I did a Google search describing the logo that I observed, and it showed me a Google image photo of that same logo.
And did that search yield any information about where those flip-flops could have been purchased from?
I don't recall on that one.
If I were to show you a copy of your report, would that help refresh your recollection?
Yes. So it's,
Did that help?
yep.
Okay.
So
So were you able to determine where these flip-flops can be purchased?
Yeah.
at?
yes.
Okay, and where was that?
So it's Athletic Works, at Walmart.
And you said that they appear to be heavily worn.
Yes.
Now, when you're inspecting these items, the jeans, the shirt, these flip-flops, why were you inspecting them?
I'm an evidence technician, for the Kenosha Police Department. So anytime that I'm taking, I was assuming that this was evidence in a case. Just taking note of anything that could be noteworthy of anything on the shoes or the clothing. So I could be descriptive in the reports. I didn't know if Detective Kennedy, who was the one that asked me to retrieve the clothing, had seen these for himself or if he's inspected them. So I needed to be able to describe what I saw so that when he reviews my reports, he would know what I saw on the items.
And you could put those back in the bag, and I'll grab them from you in a bit. Is one thing that you're looking for evidence of blood stains, other stains, things of that nature?
Correct.
And observe sort of stains on these flip-flops?
Nothing that I would be able to say that was.
And the same question as it relates to the jeans. Were there any stains that you saw on the
On the jeans, no.
And then the shirt was just the orange stain on the back.
Correct.
And the yellowish stains near the armpits that you see now.
Correct.
Do you remember also inspecting a pair of underwear?
Yes.
And do you remember any of the details regarding the underwear?
Yes, I do. I remember comparing to the other items of clothing, they appeared very worn, or heavily used, due to the elastic in the waist area was very stretched out. And then I also remember them being Fruit of the Loom brand.
And did you make a determination about any stores that commonly sell that brand of underwear?
Walmart, once again.
Walmart? And that could be a question I don't want the answer to, but were there any stains of interest on the underwear?
Not that I noticed, not that I recall.
And now when you had retrieved these items, they were in evidence similar to how they are today.
When I retrieved them from the jail?
Yeah.
No.
Okay. How were they when you retrieved them from the jail?
So at the jail, whenever you bring in an inmate in, all their items, belongings get placed in like a big blue, it's almost like a mesh style bag. That's what I retrieved them from. And then I placed them in paper bags.
So you were, to your knowledge, were you the first person that did any sort of evidentiary investigation or looking on these items of clothing?
It'd be assumed that, yes.
And so kind of the chain of that custody was, correct me if I'm wrong, but was Mr. Anderson gets booked into the jail, his clothing get put into that blue mesh bag, and then you took them to inspect them.
Correct.
And then after you inspected them and reviewed them, how did you process the evidence from there?
So I'll start from the beginning. So I go to the jail. They hand me this blue mesh bag. I put gloves on my hand, on both hands, placed the items into bags, transported them to the Kenosha Police Department's Evidence Bureau, where we process all our evidence. Typically you would there's like a large metal table in there for our workstation. Typically we would line it with a roll of like brown paper. I remember that day we were out of that paper, so I obtained several paper bags, which fits the same purpose, and line the table with those instead, just to prevent any cross-contamination of any evidence from other cases. And then again, using gloved hands is when each item I started photographing and inspecting.
And then did you eventually at the end put them in paper bags and seal them?
Yes, I did.
Similar to the paper bags we see today.
Correct.
And so just generally, the items that you observed today appear as they did when you inspected them back in May of 2020?
Yes.
I have no further questions for this witness.
Ask them.
So officer, talk a little bit about obviously all the clothing, the underwear specifically, those were actually found in the front right pocket of the Jeep. Is that accurate?
I don't recall.
Would your report refresh your recollection?
Yes.
Showing you a document pointing to the paragraph of what I believe to be relevant. So read that yourself, please.
Okay.
Does that refresh your recollection of where the underwear were found?
Yes.
Where were those underwear found?
The right front pocket of the jeans.
And the brand of those underwear were Fruit of the Loom?
Correct.
Now, the jeans themselves, in your report, did you indicate that they did not appear to be heavily worn and were possibly even new?
Yes, I did.
And did you make that determination based on the general look of them and the fact that the Levi Strauss tag on the back wasn't faded at all?
Yes.
And then with the white V-cut short sleeve shirt, you also indicated in your report that it appeared to be very new as the imprinted tag on the back of the collar was not faded at all?
Correct.
Which obviously was in sharp contrast to the shoes you reviewed, which appeared to be very well worn.
Correct.
I have no further questions. Thank you.
Nothing further, Judge.
Yeah, why don't you go run and get some, and then we'll have you in we'll take you back. Oh, thank you. Web it down, please.
Based on, we have two additional witnesses. They will be here at 11 and 11:30 respectively. The last two witnesses. The defense would like to take this time to be able to converse with Mr. Anderson about his right to testify at this juncture. So there were the issues, Judge, with the other the two witnesses that we had anticipated going earlier, the one who informed us just yesterday that he's out of state, the officer witness, and then the other witness who appears to have the flu. So that's why our other witnesses aren't going to be here until 11 and 11:30 respectively.
Do you have any rebuttal witness or available now? You don't have to.
Yeah, we told our rebuttal witnesses to be available at noon. So I think we do have two brief rebuttal witnesses. I might be able to get them here sooner, but they're not waiting in the hallway.
Well, your witnesses, have you called them and told them to get here sooner?
Yes, we have. One of them is at a doctor's appointment, so he'll be here at 11:30, and then the other one is informed that we're ready to call, but they're traveling from out of
Do you want me to?
county.
So mine are jail witnesses. I can see if I can get them here sooner. I just can't guarantee it. They were told to come in.
Well, I don't want to force you to put your case on earlier than you're required to. If they were, you know, to get it from the jail will be 20 minutes, please. So,
One is a records custodian, so she's probably working right across the street. Should we at least try her?
please,
So, okay, I'll call. Yeah,
let's see if we can keep this.
we'll see if we can at least get her here.
We'll make an effort to keep this short, but otherwise, you're welcome to have.
Still, the communication is that the subpoena has expired. That he passed the time. I don't know what that. I don't have anything to do with their subpoenas. We certainly have not told anybody. Oh, we're going to try to work out a stipulation. Figure out a way to cover it. Yeah.
Fair enough. Things with that.
Me? The school of the doctors. I feel like I'm lost in control.
But which week did you feel that?
We're not going to.
Oh, I know that, but it's poor jury.
We're committed to making sure this happens. I think it'll be awfully short, so just so the court knows about it.
Okay.
I think she'll be very.
A while with him, so we might as well take her while she's here. So I have them. Ordinarily the defense presents its entire case before the state is invited to present any rebuttal evidence. However, because of the shortage we had this morning, the district attorney was kind enough to arrange for what he describes as a brief witness to testify at this point. So, Mr. Gravely?
State calls Jill O'Hamlin to the stand.
Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated.
Ms. O'Hamlin, can you state your first and last name and please spell your last name for the record?
Jill O'Hanlon. It's JILLO''HANLON.
How are you employed?
I'm a detention systems manager for the Kenosha County Sheriff's Department.
What does that mean you do?
An array of things, but basically track inmates' activities from the time that they're booked to the time that they're released.
Are you the records custodian for records pertaining to where an inmate is located at any given point in the Kenosha County jail system?
I have access to pull those records, yes.
Okay. And did you comply with the request to indicate specifically what cell two separate inmates were housed during a time period of February 2nd, 2022 through February 5th, 2022?
I did supply some reports from our jail management system.
I'm going to show you first what's been marked as State's Exhibit 357. So that's the watch. Yep. Ask you if you are familiar with this page document.
Yes, I am.
What is that?
It's a housing history report for Marquand, Washington.
Is that an official document of the jail generated by the system that you mentioned?
Yes, it was printed from the jail management system.
And is that a system that you regularly utilize to try to gain information about where inmates are located?
Yes, it is.
Do you find the system to be true and accurate regarding the reports it generates within your work experience?
Yes, I do.
And how many years have you been a person who operated this system or the equivalent system in generating such reports?
I've been involved in the records booking part for 22 years.
Turning your attention to State's Exhibit 357, does it appear to be changed or altered in any way from the document you produced upon the request of the DA's office regarding inmate Marquand Washington?
No, it does not.
So it appears to be unchanged other than the sticker that is attached to the document?
Correct.
I move admission of State's Exhibit 357, Judge.
No objection?
No.
Ms.
Steve?
Ms. O'Hanlon, utilizing Exhibit 357, can you indicate, first of all, what block that Marquand Washington was in from the dates of February 2nd through February 6th of 2022?
Mr. Washington was housed at our detention center. He was in H South block, H West cell, bed 9.
And is that a security area, if you know, of the detention center?
That's our segregation unit.
Okay. And again, the cell number was?
The cell which was H West, the
Yep.
bed was 09.
And in that particular area of the detention center, when it says bed, does that mean, does that actually also mean cell number?
Yes,
Okay.
because the H West is broken into cell blocks, and the bed number would reflect the assignment on the bed.
So there are not multiple people within a cell within a specific room in those locations, correct?
Correct.
Okay. So bed would mean you are in a specific cell under your cell.
Correct.
And you indicated 09. Did I have that right?
Correct. 09.
I'm now going to show you what's been marked in State's Exhibit 358. And first ask you the same question. Do you recognize this document in the context of what we've been talking about?
This is the inmate housing report for Nicholas McAtee.
Generated using the same system.
Correct.
Believe that 358 is true and accurate based on your experience and based on observing this document?
Correct.
Any changes or alterations other than the sticker that you see in Exhibit 358?
No.
Judge, I'd move admission of 358 based on the testimony.
Is there objection?
No, Judge.
Steve?
And if I ask you about February 2nd through February 5th, 2022, up until 2:14 p.m., are you able to indicate inmate Nicholas McAtee's location, again, from February 2nd, 2022 through February 5th, 2022 at 2:14?
Yes, he was housed in H West, bed 20 or cell 20.
So 20 as opposed to number 9, which was Mr. Washington, right?
Correct.
Okay. And then on February 5th, from 2:14 p.m. to 8:35 p.m., so 6 hours and 21 minutes, is there a movement to a different location within that same cell block?
Yes, that'd be cell 11.
Okay. And then at 8:35 p.m. On February 5th, is there again a move to a different location than number 11?
Yes, cell 22.
Okay. And again, those are also in the segregation unit, as was Mr. Washington.
Correct.
I have nothing else at this witness, Your Honor. Thank you.
Any questions?
Yes, thank you. So, Mr. Washington, based on these records, Mr. Washington and Mr. McAtee were housed in the same unit, that being H cell block, from February 2nd through February 6th of 2022.
Correct.
Nothing further.
Ms. O'Hanlon, and it was only in those 4 days that they were in segregation together. Is that correct?
Without itemizing the whole report and going through each cell location and transaction date, I wouldn't be able to tell you off the top of my head if they're housed together elsewhere.
You're not aware of any other time they were in segregation based on what you've been asked to look at?
No.
Nothing else?
The question was asked in such a way that the no could either be saying no, they weren't, or no, I'm not able to tell.
No, I'm not aware of any other additional times they were housed together.
Thank you. Any other question?
No.
No.
Commissioner Stone?
Okay.
I think we're back at,
I was informed that our next witness has walked into the courthouse.
oh, find it.
The record is going to be Connie Hillman. And on the record, I'd like to move into evidence exhibit 299 and 300 with the jeans and the white t-shirt.
No objection?
No.
Received? favored teams in the NCAA. Would you raise your right hand, please? Solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Please be seated.
Good morning, Ms. Hillman. If you don't mind just stating and spelling your name for Madam Court Reporter.
Connie Hillman, Connie Hillman, Hillmann.
And Ms. Hillman, how are you currently employed?
I am retired.
Very nice. What did you retire from?
I owned D&M Accounting Services in Menominee Falls.
And can you explain what D&M Accounting Services, what that business entailed?
Mainly doing personal tax returns, corporate tax returns, a lot of monthly bookkeeping, payrolls.
And how long did you have that company for?
32 years.
And were you the owner that entire time?
Yes.
In your 32 years in business, did you ever have a client named Zachariah Anderson?
I did.
Okay. Did you see that person in court today?
I do.
Can you briefly point him out and describe what he's wearing?
Gentleman sitting next to you and looks like a gray suit with a blue
Pointing,
gray tie.
pointing at the accused.
Judge would ask that the record reflect that.
Right.
Thank you. So, you know Mr. Anderson, approximately how long has he been a client of yours?
I'm going to guess 2 years.
Just for record purposes, since Detective Correa is not here, I am opening what's been previously marked as Defense Exhibit 242. Ms. Hillman, in your 32 years, I'm assuming there were certain business practices and procedures that you utilized as far as keeping track of client information, things of that nature.
Yes.
If someone were to do taxes with your accounting services, can you please explain to the jury the different ways that your clients could come pick up their tax return?
Objection as to other variety of ways. Certainly something specific to this case, but irrelevant what other ways are available.
Overall,
People can show up personally to pick up and sign the documents that give us permission to e-file their tax returns. Before we e-file a tax return, we need that signature, and they have to pay us either cash, check, Visa, MasterCard, Venmo, or PayPal.
And do you provide a receipt for that transaction?
Only if it's cash.
I'll show you a couple of papers. That's Defense Exhibit 242. Look on this. Well, does this look familiar to you?
Yes, that is a receipt showing that the gentleman paid with cash.
Okay, and is this receipt, is that the type of receipt that your business utilized?
Correct.
And what would the date indicate?
May 18th of 2020.
And what would that indicate to you? What was done on that date?
Then he picked up his, looks like his 2019 tax return, which I'm going to guess was more than likely filed for an extension because it would have been due in April.
Okay. And then under this receipt is the document. Does this look familiar?
Yes, that's our tax return cover sheet that we've put on every tax return that we do.
And it looks just like the ones that you do for your tax returns.
Yes.
And you had noted already that you did in fact prepare Mr. Anderson's taxes for the year 2019.
Correct.
And the address on this tax return, is that the address of your company?
Yes.
I want to show you this piece of paper as well. Does this look familiar to you?
Yes.
Can you explain what this is?
It's just so that people have notification from us that they have 24 hours to look over their tax return. And if we don't hear from them regarding any changes, then we go ahead and e-file it. And then they can also log into a program we use called Secure File Pro. And that's where we store all PDF copies of tax returns for clients so they can download them at whenever they want.
Okay. And based on all these records and the receipt, is it your understanding that Mr. Anderson picked up this tax return packet on May 18th, 2020?
Yes.
Now, I want to talk a little bit about where your business was located. Was it a standalone building or was it in a strip mall? Like what kind of, sorry, it's very loud. Hold on. What kind of location was it?
It's in a Tri-City National Bank. It's a standalone building, and we lease the whole lower level of the Tri-City Bank.
And around May 18th, 2020, do you have any surveillance cameras or any security systems in place?
I believe we had security cameras, but we would not have had footage from that time frame, now.
Now, or closer back to May of 18th, 2020, did law enforcement ever come to your business to obtain that surveillance footage?
No.
Did law enforcement ever talk to you at all in this case?
No.
I have nothing further subject to re-correct.
Ms. Hillman, did you specifically speak to Mr. Anderson that day?
No.
So someone on your staff would have assisted him in giving him his tax return?
Right. The name on the receipt was Veronica Adamoy. She was the out front receptionist person.
But there's also a sticky note on the supplemental page about when you would e-file the return that indicated, "Will stop in 3:24 p.m. call."
That's Veronica's handwriting saying that she called him and that he must have made a notation saying that he would be in to pick it up.
And so that would be on the 18th, correct?
Right.
So at some point, she speaks to him at 3:24 p.m. and he says he'll stop in that day.
Right.
So then, per logic, you would stop in subsequent to that sometime a little bit later on. Okay. So if his phone records put him in Menominee Falls at 4:52 p.m. on the 18th, that would be consistent with him picking up his taxes from Menominee Falls on that day at that time.
Seems logical.
I have nothing further. Thank you, Ms. Hillman.
Nothing further from this defense.
Give me a step down.
Thank you.
Now, when do we next have witnesses available?
Our next witness won't be here until 11:30, Judge.
What do we take our morning break? What do you think? Please don't talk about the case during the break. Read about your list on any account of the trial. See you in a little bit.
Witness is here.
Okay.
So we were thinking Zellmann, who's our last witness, read our stipulations in, will rest, and the state would be ready to call that jailer, and then we could be done. Do that before we break.
And what about Mr.
You can take your colloquy with him before
I'll do it right now.
we'll put all
Okay.
So our proposal is, because we have all the stipulations worked out, defense, assuming that the colloquy goes in a certain way, we'll have all of that done. Then I'll immediately put on my jailer witness before they break for lunch, and then the court will be finished with evidence.
That's fine. All right. Mr. Anderson. Person accused of a crime. Well, actually, any witness has a right to take the fifth. That's, you hear that expression a lot. It refers to the provision in the federal Constitution, the Fifth Amendment, which allows a person not to give evidence against himself or any evidence at all. It's also in the state constitution. Bottom line is that you are not obliged to say anything at all in this case, testify in any way. If you decide that you do not wish to testify, there'll be no mention made of that unless you request that it be mentioned or one of your attorneys mentions it. If you decide to remain silent, I will not comment on it. The district attorney will not be permitted to comment on that. And the jury will either be given an instruction that they are to disregard the fact that you decided not to testify and may not consider it in any way in reaching their verdict. If you decide that you do want to testify, then the district attorney will be allowed to question you about anything which is germane to this case. Relevant, pertinent, and that could even extend to matters for which you're not on trial. An example would be if it's relevant to this trial, and I've ruled some of it irrelevant, but if it becomes relevant to the trial, he could ask you questions about marijuana that if they're relevant, pertinent to the case, you'd have to answer and could not take the fifth on those. You can't selectively take the fifth on some matters and not on others. Once you're on the witness stand, once you testify, he can cross-examine as to any matter pertinent to this case, and you will have no right of silence with respect to those. I'm not suggesting that I would permit him to examine you about that. But if, as the evidence develops, he feels it becomes relevant, he can make another shot at trying to let me testify and trying to get me to admit evidence about that, and then in that event would be allowed to question you about it. So that's one thing. He can ask you also about any criminal record. Is there a criminal record? You can ask about a criminal record. You'll have to clear that with me first. Or any recent act of dishonesty may be something that he'll be permitted to question you about. You understand that? Any question about this at all? If you decide to testify, you'll have a choice. Either I will say nothing about it at all and district attorney can't comment on it. No, what am I doing? If you decide to testify, the district attorney will be allowed to comment on your testimony, and you'll have the choice whether you want me to say nothing on the subject of your decision to testify, or, I'm sorry. It's Monday. If you decide to testify, then there will be an instruction given about weighing the testimony, which provides that your testimony should be weighed as the testimony of any other witness. Considerations of interest and other matters bearing upon credibility apply to the defendant with any other, as well as any other witness. Pardon me?
I can't hear you.
I instruct the jury that just because the defendant is charged in this case, you should not discredit his testimony. That's the language you're talking about.
Yes, thank you. I knew I was struggling with it a little bit. So there will be some discussion about your testimony if you decide to testify but it will be along the lines that Mr. Ober has indicated. You have any questions about this at all?
I think all the questions I have are now sitting with at least two of my three attorneys. And I would like a little bit more time for them to consider what I've asked of them, but I will be doing whatever they recommend anyway. So largely it's going to be on their advice. And I think they're pretty clear on how things are going to go.
Okay, well, I'm going to continue the discussion now. And I'm going to rely on them to communicate to me what your final decision is. And you can't change it up to the last minute, but I need to know about it. So if your lawyer says, calls you as a witness, then I will take that as indicating that you have made a final decision one way or the other. If he calls you to testify, meaning that you've made a decision to testify and give up your right to remain silent. If she tells me that you don't wish to testify, then I will take that as an assertion of your privilege, and that will proceed with the case on that basis. Any question about this?
Oh, I understand.
Has anybody threatened you or pressured you or forced you in any way?
In any way regarding my
A decision about testimony?
No.
Has anybody promised you anything in exchange for this? Is your mind clear today?
I believe so, yeah.
Are you feeling all right?
If that can be.
Have you ever been treated for a mental or emotional disorder?
No.
Where were you born?
Washington.
And Port Washington? And do you have any questions at all about your rights here? I have to say I didn't do as well as I could have done in explaining it to you, but just so you understand, it's your decision and no one can force you in any way against your will. And even if you decide to overrule what your attorneys are suggesting, that's your decision entirely, and they have to accept it. And as do I.
Yeah, I think my attorneys gave me an excellent explanation. I do have concerns. I do have questions, but as far as testifying is concerned, I think they were very clear with me about that. And like I said, I would like a few more minutes to talk to them about a concern. I don't know how they're going to address it, but I think we're already basically on the same page. How things are going to go forward.
And you will have a little more time before the occasion arises for you to decide. But at this point, as I indicated, I'm going to assume that you're fully comfortable with whatever questions, maybe not what they ended up telling you, but that you've been fully advised and you've made a decision based upon your own considerations and their advice.
Yep.
Okay.
Yes.
Any other question anybody wants to ask?
No, Judge, not at this time. We're just waiting on, I did send that second stipulation to the clerk, so we're waiting on getting that. We can sign it and we'll be ready to go.
So is our plan then to present the rest of the defense case, including the stipulation, and then for the defense to rep and the state to try to present its witness before lunch?
Yes.
Okay.
But if it gets really late, we'll break for lunch before your witness.
Okay.
Okay. All right. I'm satisfied that Mr. Anderson is acting freely, voluntarily, and intelligently, understands the nature and qualities of his acts, and he needs a little more counseling with his attorneys, he wishes, and then whatever decision he makes, I'm satisfied there is no constitutional impediment. Anything else before we start? I would rather just get that stipulation. What's the sequence?
We were thinking Zellmann, last physical witness, then I would
Zellmann.
read in the two stipulations, defense would rest, state would call their last rebuttal witness.
I wasn't remembering the name. So let's go with that then. I'll call the jury down.
The defense would call Kurt Zellmann.
Raise your right hand, please. You solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
Please be seated.
Good morning. If you could just state and spell your name for the court reporter, please.
My name is Kurt, K-U-R-T. Last name is Zellmann, Z-E-L-L-M-A-N-N.
And what is your title? Is it Mr. Zellmann?
I'm the Deputy Fire Chief for the Southern Ozaukee Fire Department.
Deputy Zellmann would be fine.
Deputy Chief is just fine, yes.
Okay, great. Thank you. You just said what your position is with the fire department, but if you can kind of go into what your position entails.
Kind of a jack of all trades. I'm number 2 in charge of the fire department. I oversee both the EMS and the fire inspection prevention bureaus and the training bureaus.
And you were kind of jumping to it. In May of 2020, you were actually called to the home of Mr. Zachariah Anderson.
That is correct.
And you were called to put out a fire that was on the property.
I was called in as support with our fire apparatus to make sure that the fire didn't roll. It was already out when I got there.
The fire was already out?
Yes, ma'am.
Okay. And in this matter, were you ever asked to see if there were any burn permits that were associated with that address of 6813 West Highland Avenue?
Yes, we did receive a information request for burn permits at that property.
And can you kind of explain what burn permits are for in the city of Mequon?
In the city of Mequon, we do allow open burning of only natural materials that originate from the property's residence or the property itself.
And these burn permits, is this something someone has to apply for?
Initially, yes, ma'am. Burn permit is applied for. We go out and inspect the property, make sure that it's suitable to burn, that they are within all the regulations, and then we issue the permit. Renewals are generally, as long as the person doesn't change any of the initial, we don't go back out and re-inspect.
So when you go to inspect, what are some of the things that you look for to pass someone for inspection for the permit?
That there's a containment system for the fire or rocks or something along those lines, that the size of the burn permit is within the, or that the size of the burn location is within the correct parameters of the permit, and that the setbacks are followed.
And if a permit is generated for an individual on the property, would that mean that they passed the inspection and that the burn pit had been inspected?
That assumption could be made, yes.
Okay. In looking whether the property and Mr. Anderson had permits, were you able to find any information about permits being obtained?
Yes, I was able to locate in our database the years that permits were obtained.
And can you explain the database for the jury? Basically how those records are stored?
It's simply an Excel spreadsheet that we add a tab each year for each year that permits issued.
And are those records accurately kept?
Yes.
The foundation.
Okay, great. Thank you.
Yep.
I'm going to hand you what's been marked. Well, before that, Do you remember the years that Mr. Anderson had burn permits for his location at 6813 West Highland?
I'm sorry, I don't remember off the top of my head, no.
Okay, I'm going to show you what's been marked as Exhibit 359. And this is Defense Exhibit 359. Can you explain what that is?
This is the form letter that each time a burn permit is issued is provided to the person requesting the permit.
And what year is this permit for?
2018.
And was there a time where you changed your database so that records previous to 2018 would not be accessible as far as printing out the permit records?
Yes, the database itself only goes back a few years. Before that, it was essentially a handwritten operation prior to my employment there. So I don't know exactly what year the database converted to electronic.
Okay, and that 2018 burning permit, when did it expire?
All burn permits in Mequon expire December 31st of the year of issuance.
And then for the 2018 burning permit, what was the address of the burn site?
This permit is issued to 6813 West Highland Road in Mequon.
And the resident?
Mr. Zachariah Anderson.
Okay, and did it have a note of where the burn pit would be?
Yes, it's noted as south of the house.
Okay. I'd ask that Defense Exhibit 359 be introduced or received.
Received.
Handing what's been marked as Defense Exhibit 360 to the witness. Can you explain what that is?
This is a burn permit for the year 2020 at the same residence.
Same residence, and is it the same resident?
Yes.
That would be Mr. Anderson.
Yes.
And the note as to where the burn pit would be for 2020, was it the same as well that was south of the house?
Yeah.
And that burning permit would have expired on December 31st, 2020.
Correct.
So I'm going to ask that Defense Exhibit 360 be received.
No objection.
Steve.
So can any resident of Mequon apply for a burning permit?
Yes.
And is that something that residents of that town have to do if they want to have fires on their property?
That is correct.
And to your knowledge, do a lot of people in the Mequon area get burn permits?
Check.
Roll.
Sorry, you can answer.
What's the lot?
Do you know the number of permits approximately that are issued every year?
I'm sorry, I don't, because our secretary is the one who does the issuance. So she keeps count. I don't.
In your work there as deputy chief in the city of Mequon for the fire department, have you seen people do burns on their property in the city of Mequon?
Yes.
And if they were to do that, they would have to have a permit.
That is correct.
I have no further questions subject to redirect.
Zellmann, does the burn pit permit an individual to burn a bleach bottle or any container of bleach in their burn site?
No, sir. That would be not possible.
Okay. And what about clothes that have metal buttons on them? Would that be a permitted item to burn in any burn site that these permits involve?
No, sir.
What about steel-toed boots? Are those legal to burn in these burn pits?
No, sir.
And what about underwear and socks? Are those items legal to burn?
No, sir.
Okay, so those are not covered by the burn pit that you've been shown as an exhibit today. Is that correct?
That's correct.
I have nothing else, Judge.
In your experience of seeing people's burn pits and what they throw in it, if you have to put it out, is it common that in areas such as Mequon, people will burn some of their trash?
If they are doing so, it's in violation. I have gone to reports of items being improperly burned. Yes, so I have seen other people improperly burn items in the city of Mequon.
No further questions.
Do you recall the date of this incident? In other words, the time period of around May 19th, 2020, May 20th, 2020?
Are you asking about the
Do you recall going to this scene?
Yes.
Okay, I mean, you have your own independent memory.
Yes.
Okay. Had there been heavy rains the days before that?
Yes.
And you found that there was still a fire that required some intervention by you to allow people to go through it. Is that correct?
That is correct.
Even though it had been a heavy rainstorm.
Correct.
Nothing else.
I don't have anything else for Deputy Chief Zellmann.
You may
Thank
sit
you.
down, sir.
The defense would like to read in two stipulations as far as it relates to the defense's case.
Go ahead.
Thank you. The first stipulation I will read is marked as Defense Exhibit 361, that the below signed parties stipulate on May 26, 2020, Officer Kyle Morrissey of the Kenosha Police Department obtained video footage from Casey's General Store, 280 Highland Drive, Fredonia, Wisconsin, and Ozaukee High School, 401 Highland Drive, Fredonia, Wisconsin. The video footage was later reviewed and nothing of evidentiary value was located. This is signed by Attorney Michael Gravely and myself, dated today. We'd ask that Defense Exhibit 361 be received.
And is that agreed?
It is.
And as I indicated earlier, in the trial, several weeks ago, when something's stipulated, that's agreed by both parties as being accurate, and no further proof will be received on that subject to either bolster it or to question it. Any question about that? Okay, thank you.
The defense is going to read the second stipulation, which is marked as Defense Exhibit 364. It reads, the following are statements attributed to Detective Lauren Anschutz of the Kenosha Police Department, who is an unavailable witness in this matter at this time. The parties have stipulated that these statements should be read in their entirety to the jury in place of testimony that Detective Anschutz would have made if he had been available. On May 19th, 2020, Detective Anschutz interviewed O.A. During that interview, O.A. told him the following. Her brother was playing with Legos in the basement of her father's home because he likes it down there. He went down there to check on him. O.A. told Detective Anschutz that she never saw the unregistered gun and that she never saw any guns here in Wisconsin. In Detective Anschutz's report, he reported that during a phone conversation with O.A. on May 22nd, 2020, O.A. stated the following. Mr. Anderson never took the chainsaw out of the back of the van. In Detective Anschutz's report, he reported that on November 6th, 2020, O.A. stated the following. Mr. Anderson brought a chainsaw on the way up to the tree farm. When they went to the tree farm, Mr. Anderson and her uncle were fixing the chainsaw. When they left the tree farm, Mr. Anderson took a different chainsaw home. Once they arrived at the tree farm, Mr. Anderson borrowed Grandpa's work boots and took off Grandpa's boots and placed them in the van and took them home. She believed Mr. Anderson had a storage unit. Mr. Anderson told her he had to leave to go to the storage unit one day and returned 10 minutes later. That's a stipulation that's signed by attorney Michael Gravely and myself, dated today. We'd ask that Defense Exhibit 364 be received.
Okay, stipulated?
That is stipulated and
All right, they'll be received and are stipulated too.
Time the defense rests.
All right, and Mr. Rivley?
state has one witness. And that is Officer Quintana.
You tell me where the testimony you're about to give in this matter with the truth, the whole truth, and nothing but the truth shall be God.
Yes.
Please. Sure.
Can you please state your first and your last name and spell both your names for the record?
Erick Quintana, ERICK QUINTANA.
And Officer Quintana, where are you employed?
Kenosha County Detention Center,
And what's your position there?
Direct Supervision Officer.
And so, Officer, how long have you been employed at the detention center?
It'll be 5 years next month.
So I want to ask you about a particular area of the detention center called H West. Can you briefly describe what H West is?
It is a disciplinary unit. When an inmate commits an infraction, he is sent there for discipline for X amount of days.
And how many, do we call them cells in that area?
Yes.
How many cells does that unit have?
22.
22. And how are they tiered? Are they all on one level or are they on two separate levels?
1 through 10 is on the bottom, 11 through 22 is on the top.
And when an individual is in H West, and I'm speaking now about back in the time period of February of 2022. So if things have changed, please alert us to that. Okay. In February of 22, what was the arrangement for an individual who was assigned to H West? So how long would they be in their cell versus in other locations?
Usually sometimes like there'll be a malfunction and we'll have them going from a different cell. That's the only time they're moved.
Okay. And so how many hours a day are they in their actual cell?
23.
And then for that last hour then, unaccounted for by in the 24, what is happening to an inmate who is in H West?
It is their rec area. They're allowed to be in the day room where there are lines they cannot cross. They have to stay in a specific area.
And where are the officers, meaning jail staff, who would then monitor compliance with that? Where are those individuals located?
It's the officer station. We call it the bubble, and it's looking into the H West day room.
So, and I assume it has a vantage point where all of the cells are visible?
Yes.
And how many officers would be assigned to monitor H West at any given time?
2 officers.
2 officers? And are they both located in what you call the bubble typically?
Yeah.
All right. I'm going to ask you to just orient me through a couple of pictures. And first of all, was a request made that you take a couple of pictures from the vantage point of particular cells? Was that what you were asked to do?
Yes, my supervisor instructed me to take 2 pictures from each vantage point.
Okay. And what did you utilize? What piece of machinery or equipment did you use to be able to take those pictures?
We have a body camera right here, and we're allowed to take pictures.
You're being asked to speak into the microphone a little more directly. You have a soft voice, and this is a hard room to hear it. Okay, so you could speak up. So again, answer my question.
We have a body cam.
Okay.
And it allows us to take pictures when we change the options.
And did you do that upon our request?
Yes.
Okay. So I'm first going to have put up on the display up there what's been marked as State's Exhibit. Is it 362?
362.
362, officer. My first question is, did you take this picture once you see it?
Yes.
Did you take that picture?
Yes.
Okay. So what cell are you directly in front of and facing out from when you took this picture?
To my back is H West 9, and I'm looking into H West 20.
So if a person was assigned in H West 9, this would be what they looked out and saw from the very front of their cell?
Yes.
Okay. And is this picture, which is 362, is that a true and accurate copy of the vantage point from cell 9?
Yes.
Is there any changes or alterations from what you know to be the vantage point from cell 9 that in this picture, other than the sticker being on there? Otherwise, is it a true and accurate copy of what you see when you look out of 9 today and back in February of 2022?
That is what you would see. That's what I would see, but the inmate would be behind the dash.
So his visibility would be even more compromised?
Yes.
Okay. But if you're right at the doorway and out of the doorway, this is what you see?
Yes.
Judge, I move admission of Exhibit 362 based on the testimony thus far.
No.
So from this picture, are you able to orient us as to where cell number 20 is?
Cell 20 would be over here.
Okay, so it's on the separate tier, correct?
Yes.
And it is that essentially as far across as this particular dorm or jail area takes you? It's on the far other end?
Yeah, it's the opposite side.
Okay. And it's upstairs at that location, is that right?
Yes.
So for 23 hours a day, an individual in cell 9 would only see the individual in 20 in the vantage point you've just shown me. Is that correct?
Yes.
Okay. So what if a person was moved to cell 11? Is 11 visible in this picture? And if it's not, then just please tell me.
It is not visible.
Is 11 the neighboring cell to 9, so it would be right next to it?
No, it would be above.
Okay. So 11 is, I see like a ceiling on this. You see what I'm talking about?
Yeah.
Okay. Is it above the ceiling?
Yeah.
Is it directly above 9, or is it directly above the neighboring one, which I assume would be 10?
It would be the neighboring one above.
Okay. So it's directly above the neighboring cell.
Yes.
All right. And then if one was in 22, where is that located?
22 is going to be way at the end. Right about there.
So that would even be slightly farther than 20?
Yes.
What would be the distance between cell 9 and cell 20 during those 23 hours a day? How far away would you estimate those two are in distance?
I would say approximately 50 to 60 feet.
50 to 60 feet. Okay. And is this a area of the detention center that you have worked in often in your career?
Yes.
Describe the ability of someone from 9 to communicate to 20 or 22. What tone of voice would you have to use in a normal situation to be able to get the people in 20 and 22 to be able to have a conversation with you?
You have to talk pretty loud. Basically, you'd be yelling because they're on opposite sides of the room and there's a lot of echo.
And what, if anything, can you say about whether that yelling would be something that other cells would hear? I mean, in other words, is there some kind of ability to yell in a targeted way, or would other cells also hear it if you yelled, again, from 9 to 20?
No, all the cells will be able to hear.
So if I were to simply whisper or speak in a very conversational voice, I had something confidential I wanted to say from 9. Based on your experience in this area, would 20 or 22 be able to hear me?
On a whisper, no. You just have to talk a little bit louder than normal just for them to hear you from 20 to 22.
Okay. From 9 to 20 to 22?
Oh, you'd have to talk loud.
Okay.
You're not going to whisper that.
Okay. So only if 20, 22, which are close by cells, correct? Correct?
Yes, correct.
Okay. In this, there is, it looks like there's a red line. You see the line I'm talking about?
Yeah.
Can you just point out where that red line is for the jury? So just draw where that red line is so that they know what we're talking about.
The red line?
And does it go on both sides of the stairway there, that as depicted in this picture?
Yeah, it cuts off the stairs, then it cuts off part of the day room on the other side.
Okay. And what does that red line mean in the context of the rules or life in H West?
When you're on discipline, you're not allowed to cross those red lines for any reason.
And are people on discipline? Is that, if you're on H West, are you on discipline automatically?
Yes, most of the time.
Okay. So, are there ever times when a person who's housed in H West can go closer to that than that red line in the 1 hour a day that they're out?
The closest you'd be able to get without crossing it would be here and here.
Okay. And that's only for 1 hour a day at maximum?
Yes.
Now, if you're in the upstairs tier, are you allowed to walk into the downstairs tier during your 1 hour?
Yes, everyone's allowed to walk in that red area.
And if you cross that red line, then what happens?
One of two things. One, you get a warning. If you do it again, your recreation's over. Or you can just tell them it's over right then and there.
And does that come from the two people up in the bubble?
Comes from one or the other.
Okay. And is this something that you believe is regularly and consistently enforced?
I enforced it, yes.
Okay. I'm going to show you now what's been marked as State's Exhibit 363. And just let me know what this is in relation to this case. So what is Exhibit 363? First of all, is this a picture you took?
Yes.
Is it, again, a true and accurate vantage point from the place you were situated when you took this picture?
Yes.
Does it accurately reflect the distances from one end of this cell block to the other and where the cells are that are in question in this case?
Yes, it is accurate.
Do you think it's changed or altered in any way other than the sticker that's on there?
No.
Again, I'd move admission of 363 based on the testimony, Your Honor.
Okay.
Yeah.
So from 363, what is our vantage point?
You're standing in front of H West 20, looking at H West 9.
Okay. I think we locked you in the microphone. So one more time.
I'm standing in front of H West 20, looking at H West 9.
So where is H West 9 on this photo? So the jury knows where a person who's in 9 is located.
Right about here.
Under the stairwell and on the back, towards the back wall?
Yes, in that corner.
So it's the far corner under the stairwell.
Yes.
Are there occasions where two inmates are ever out for rec time at the same time, or is that something that is forbidden?
No, that is not allowed.
Okay. Where is 22 on this? If you can see it, where's 22 on this particular exhibit?
You won't be able to see it. It's 2 cells this way, like to the left.
And the red line that we're depicting here, is that same red line we saw in the other picture?
Yes, it is the same red line.
Just a different vantage point.
Yes.
Okay. I have no further questions.
Thank you, Judge. I'm gonna keep 363 up. The state had asked you, that this is the vantage point from cell 20, correct?
Yes.
And again, that's from outside the cell, not inside.
Correct.
Because a view from inside would be obstructed.
Yes.
So if the state had asked you about the noise and stuff like that, and you're familiar with working in H block, right?
Yes, I'm familiar.
And it can get, you said, echoey.
Yes.
And so if someone says something and it is not a whisper, chances are other people in the unit are going to be able to hear it.
Yes, correct.
And so if you're in a cell and you hear something coming from a different cell, it might be difficult to pinpoint exactly what cell it's coming from.
Yes, correct.
It's only potentially that you can know who it's coming from based on your experience by sound of the voice, if they're saying who it is, those type of identifying factors.
Yes.
And so coming here then from the picture we see, can you see cell 11 in this picture?
Yes, I can see cell 11.
And can you point out to the jury where cell 11 is?
Right.
Okay, and then where is cell 9? So these are relatively close to each other, just on opposite tiers.
Yes.
So before the state had asked you that if you're whispering or talking quieter from cell 9, would it be difficult to hear in cell 20? You gave an answer. But as far as with cell 11 and cell 9, individuals would be able to speak quieter and maybe be heard just by those cells.
You'd have to talk a little louder, not as loud as 9 and 20, but you still have to talk fairly loud because they're on opposite tiers.
But you don't need to yell.
Correct.
How often did you work in H West?
I was pretty often on it on night shift. Nice to work it.
A night shift?
Yeah.
Okay. And the state had asked you about the rules about rec and staying inside the red lines. There are times where individuals housed in H West do go outside those lines.
Yes.
And some deputies and correctional officers, some of them might not say anything.
I'm give them a warning.
A warning, but they're not gonna. Some don't enforce it as heavy as others, correct?
Yes.
That'd be a fair sentiment.
Yes.
So there are times where other inmates do go up to the cell doors of the others.
Yes.
And they talk to one another.
Yes.
And this would be during the rec time?
Mm-hmm. Yes, it would be during rec time.
Okay. When people get transferred in H West, do you have to update the records?
Yes, we do.
And so if someone gets switched in between shifts, it would be the next individual that has to update the change?
No, it's the officer who made the switch updates it.
Okay, and do you update that immediately or at the end of your shift?
I update it immediately.
Okay. And you also had talked about how you had a request made to take these photographs?
Yes.
When did you receive that request?
It was on Thursday before my weekend off. Supervisor called and then instructed me to take pictures, and I did it with my body cam.
Okay, just this last Thursday.
Yes.
I have nothing further.
Questions?
So during rec time, is a person who is residing on the first floor able to go onto the second tier ever?
No, they're not allowed to do that.
So that's never permitted.
No.
And if and did I hear you correctly that based on the mesh and the obstruction and the echoes and so forth, that you believe that it is often difficult to tell which cell is communicating with another cell? In other words, if you're in a cell, you might not know which other cell is talking to you?
Yes.
Nothing else.
I have nothing further, Judge.
You may sit down, sir.
Your Honor, the state has no further rebuttal at this time.
The defense has no rebuttal witnesses, Judge.
Right. Let's take a break at this time, and I'm going to ask that you return at 2:00. Please don't discuss the case with anyone, not even another juror. Rewatch your lesson when you come to the trial. Any questions? Thank you. I think I could have done a much better job than I did. And it's important enough that I think it needs to be recovered. So that you understand, your options are that you can testify in the case if you want to. If you do decide to testify, then the district attorney would be allowed to cross-examine you, question you about anything which is pertinent to the case, which could involve matters for which you are not on trial, and you'd have to answer those questions. He would also be allowed to question you about any matter, recent event, which would be suggestive of dishonest behavior, and you'd have to answer those questions, even though they don't directly relate to what is on for trial here. And he could question you about criminal history, and he'd be limited to asking you if you've been convicted of crime before and how many times. If you correctly answer those questions, that would be the end of it. If you did not correctly answer those questions, then he would be allowed to go through and identify specific crimes, dates, and places of conviction. Any question about any of that?
No.
Okay. If you decide you do not wish to testify, then there'll be no cross-examination. You won't be questioned about anything about this case. And you would have the option for me to instruct the jury that your silence must not be considered in any way. Defendant in a criminal case has an absolute constitutional right not to testify, and his silence must not be considered as evidence against him in any way, or be considered in any way by the jury in deliberating on their verdict. You understand that?
Yes.
I would give that instruction only if you requested it. If you did not request that instruction, then I would not mention anything about your decision not to testify in the case. Understand that?
Yes.
The district attorney would not be allowed to comment at all on your silence if you decided you did not wish to testify. Do you understand that?
Yes.
Any questions about this at all?
No.
Have you had enough time to discuss this matter with your lawyers?
I believe so.
And have any questions that you have been answered to the best of their ability and your satisfaction?
I believe so.
Okay. Any question anybody wants further asked?
Judge, I would just say that we, as a team, have talked to Mr. Anderson about all the pros and cons, just like the court laid out, and so it's fully informed, knowing that.
Okay. Anything that you had to comment?
No.
Okay. Then what's the plan when the jury returns?
So will the jury, will Judge want to have a court conference with us?
I proposed, I hope, to send you electronically proposed instruction draft number 1. I hope so. I hope you have within about a half an hour, so you have some time to review it, and then we will discuss it when the jury when we return. Given what you've already sent me, I don't think it'll be too lengthy. And anything else?
Well, I think that the parties just want to know what the court is contemplating for this afternoon. So, is the court hoping to instruct, but have us argue first thing in the morning, or is the court still hoping to argue this afternoon? What is the court's preference?
I think it.
Would we be back?
I think it's unrealistic to try to complete everything today, and I don't want to break the arguments up. So, yes, I will instruct this afternoon, and then we'll start with argument in the morning.
Yeah, that's fine with the state.
And I won't put a time limit on you, other than when I was a young man, I used to. We lived across the street from Kenneth Brew, who was an eminent federal judge in Milwaukee for many, many years. And I would shovel his snow. And the only advice he ever gave me, even though he knew I was in law school, was, I think he probably said, stick to shoveling the snow. But he said, the brain cannot absorb what the seat cannot endure. So I think that was wonderful advice from him, and I'll repeat it to you. So,
And Judge,
and I do need to leave here at high noon tomorrow.
Yep, understood.
I need tomorrow, that's
For
fine.
2 hours.
And then, just because you're going to be drafting up those jury instructions, the defense would be seeking instruction 315.
Yes. Okay.
Just so you know to include that.
Sure. Yeah, you should have them within
Do you want us back here physically at 2 as well?
at 2:00. Yes, be back. And I did not ultimately. I didn't want to give 2 separate instructions on counts 1 and 2,
Okay.
but
The more verbose one for both of them?
I am giving the standard, but I'm going to omit the paragraph you deleted from both.
Okay, perfect.
Are you ready for the card?
Yes, thank you. Yes, thank you very much. Send you proposal draft number 1. It's supposed to have a stamp on it, draft number 1, but I guess I forgot to do that. Then, oh man. I also didn't number the pages. But anyway, has everybody received copies?
Yeah.
Couple of preliminary matters. There was a request by the state for prisoner status is an issue, and I'm not giving that because that refers to cases where the status as a prisoner is actually an issue. Or when, for example, battery by a prisoner.
I don't think we asked for
So I
that.
think that could be taken out.
Done.
Done.
All right. You didn't send that?
No.
Okay. Blame shifting. All right. Any problems with the first page, which is not numbered, but first page?
Nothing on the first page.
That's a standard. Then page 2, information, not evidence. The charges. Then
Judge, in regards to page 2, and I think the state can speak more to this, is they had proposed specific language for counts 1 and 2. The defense would have no objection to that, so I'll let the state be heard, but I know that what was included starting on page 2 was different than what the state had submitted.
you're correct.
In looking at the language for stalking, because there are so many and or propositions, it becomes so cumbersome to read that I wonder if the court would be willing to look at our suggested proposal, because it removes all of the essentially or ones to make it more streamlined and understandable.
Why do you charge it that way? That's how the information comes to me. That's the charge against the defendant.
Because that's how it is generated in our program. And I can't speak to that. What I can speak to is, I think, the same level that I'm sure the jury feels, which is all of the or this or that. I mean, it becomes very cumbersome. So when I streamlined the proposed ones, it specifically has fewer, obviously, or situations, but also it removes a lot of the potential ways someone could stalk someone else that don't apply here, which is what the pattern instructions actually call for, is to be more specific.
And we wouldn't have all of these problems had you charged it, because you recognize the problem. The problem is that you divided it in 2 separate instructions, even though there are 2 counts, but I prefer to instruct once on the crime.
Okay.
You have one for Sadie Beacham and one for Mr. Gutierrez.
Correct. So
I propose to give only one.
If the court would be willing, I have access to be able to edit it here. If you would prefer the language of where you have it as of another, and to take out the specified victim's name for counts 1 and 2, I believe that then we could go with the Sadie Beacham pattern instruction, which I believe would cut down on a lot of reading for the court in terms of all sorts of additional options. So if the court's willing to do that, I will make that change here while we sit here and save us all some time.
You make it so I can't even argue with you.
Fantastic.
All right. Yeah, please do that. Because the biggest problem was covering all kinds of areas that didn't need to get covered. And the second problem was doing it twice back to back. But if you cure up those problems, then I'll be delighted. So then, and in the meantime, you also had submitted, and both because of some CCAP issues in copying, I didn't eliminate some of those various ways in which the crime can be committed that you spoke of before lunch. And so if you can strike off those that are inapplicable,
Will do.
yeah, that'd be great. Okay, so then let's skip ahead to
You're gonna need to give her a moment to switch those up, though.
all right.
She will not be able to listen.
No, we can probably move on. Well, I'm just having to change names. So I know Ms. Muller and I have kind of already went through some of the issues we saw, so I can rely on her to yell some of those out.
Yeah.
Okay. In the meantime, is there any problem with the count 3 instruction?
Yes, the court has the first name of Mr. Gutierrez as Rosales. It should read Rosalio.
Well, don't blame me. That's the computer.
The computer.
Yeah.
Yeah.
You're right.
But besides that, I had no other edits for page 6 or count 3.
Okay. And then the fourth count?
So under the 4th count, under the law, it says, oh, I'm sorry, my computer is being all annoying.
Must be the
It
wrong.
says it's the 4th count, and then it says between the dates in the city of Kenosha, Kenosha County, Wisconsin, hit a court. So the defendant needs to be added into that.
Oh, I changed did hide. The district attorney is still using language like to wit.
No,
And-
sure,
and-
but it doesn't have a
and it's-
subject.
Yeah, you're right. That it creates a problem when I change it without putting the defendants because. Yeah, you're right. So I'll put in the defendant hit a corpse with the intent to avoid, etc.
Yeah, thank you. But then there were no other substantial issues with the remainder of that instruction.
Okay.
The next issue that I had come across was on page 11, Judge. The stricken testimony instruction was there for a second time. It was a repeat.
Well, I thought I had taken it out because there was stricken testimony, yes. Thinking that there wasn't, I took it out and then I noticed it was submitted, so I put it back in. So I'll strike it once.
Yeah. Thank you. And then let me know when you're ready for the next one.
Okay, improper questions. Well, in evidence defined improper questions, objections.
That was all fine, Judge. And if you-
That's where the second time the stricken comes in. Okay.
correct.
Then testimony of a witness granted immunity or other concession.
Yep.
Any problem with that?
No.
Prisoner or witness.
We're taking that
That's the
out.
one I don't propose to give. The cautionary instruction.
Yes.
And I noticed I had to put it in at the end so I wouldn't forget about it when I first was working on these. So that second appearance way at the end will not be involved in the case. Evidence of other conduct. Any objection to that?
No, and I'll just
Oh, that's
note.
one. Yeah.
I'll just note that that was the proposed language that the defense had provided to the court.
Good. I was able to import that.
Good.
Credibility of a child witness.
Yes. That was requested by the defense.
Any objection?
None.
Agreed facts. Any objection?
Nope.
Exhibits. Any objection?
No.
Yep. No kidding.
Circumstantial.
Nope, that's fine.
No objection.
No objection.
Remarks of counsel.
Fine.
Fine.
Closing arguments. Weight of evidence. Jurors' knowledge and expert opinion. Any objection?
No objection, Judge. What the state and myself did confer on, though, was as it relates to expert opinion, we believe 205 should be included because there were a couple of hypothetical questions that were proposed to experts during the trial. So we would just ask that 205 be inserted, and the standard language of that instruction is fine.
Agreed?
Yeah.
Let's see. Credibility of witnesses. Any objection?
Nope, fine.
No.
Oh, except that the very last paragraph on that page, the defendant is specified in this case. I won't give that, of course.
Yep.
Impeachment of witness by prior conviction.
So that number, it says, evidence has been received that 2 of the witnesses, the state and myself counted that there were 4 witnesses that had prior convictions. So just to change 2 to 4.
Well, actually, what I usually do, and I'm sorry I put the 2 in there, I usually say evidence has received that some of the witnesses.
I think that's fine as well, but the number 2 is.
Either's fine, but 2 is just inaccurate.
Yeah. Defendant elects not to testify. You did request.
Correct.
Okay. The closing instruction.
Looks fine.
Well, actually, it's not. I turn the page here and first thing I see, the President of the United States. and that's from a different trial. I
Oh, I am seeing that.
gave some instructions about the freedom of the jury to do what they wanted, and not what.
Wonder what trial that was.
Yeah.
So I will give
Standard one.
either the standard or something very close to it. Then verdict submitted and unanimous verdict. Any objection?
No. And no objection there, Judge.
And then that remainder of the questionnaire, that's all out.
Yeah, and then that 275 that's at the end will just be taken out.
Yep.
I didn't have any other notes. I don't know if the state did.
I did not.
Okay.
And Judge, I'm sending to your clerk right now that jury instruction for count 1 and 2.
Very good. Thank you. Thank you. Electronically.
Yeah.
Well, yeah, print one too.
Well, here's just a copy.
Well, print the copies for them too. So make 4 copies. Huh? It's the same problem I had before. That's I think that's a CCAP problem.
You able to open it?
Just print it. We'll get it open later. Oh,
I will print it to my office. I will run and go get it.
might work.
Yeah. Or take, or fairly just running it over. Here. Already got it.
You can't put a foreign hard drive into the state system.
Well, looks like I'll have to retype everything.
Actually, if
You can scan it in.
which paragraph did you take out? Yeah, I like that idea.
Scan it in?
Well, I can scan it into my phone.
Why would that work?
Is that there? Yeah.
No, so I'm having a physical copy run over, and then it's.
But I don't know if it'll let.
Before when I sent the PDF, it didn't work.
But what a bunch of dinosaurs in here, you know? At least she knows what
Yeah, I did type
she knows what she's doing.
You can send it in a different book format, I'd be able to. I don't think they're gonna edit it. If he had the capability, then we gonna. I know.
and then convert it back to or
I don't know if I have that ability.
Even if I have a PDF that should be fine,
I'm gonna send it to you, Judge.
except that's, let's see, that looks like the one in the pattern instructions. And that would be unedited.
Yeah, see, I have it, I don't have the word version. Yeah. Yeah. Right. No. Where do you see that?
on the right hand side. Here?
Yeah, but it won't be, it's gonna say.
Oh, that you, oh, you have to purchase the, yeah,
Oh, yeah.
yeah. Didn't work.
Yeah.
Oh. PCAP won't purchase the plan we need converted. Thank you.
You guys remember this? This is just called paper.
Yeah, we can do the electronic version later. You got everything set now, I think. Any other concerns with the instructions?
Not that I'm aware of.
No.
All right, let's call adjourn.
You're going to ask them about 8:30.
I am. Just to acquaint you with the schedule going forward, you're almost done. I'm gonna instruct you on the law this afternoon. It's going to take about, I'm going to say, half an hour, and then you'll be released for the day. And then I'm going to ask that you return tomorrow at 8:30. Is that convenient for everybody? And we'll hear the final arguments of the attorneys at that time. We hope to be done by noon and have the case in your hands then. That's not a promise, but that's the hope. Like when I told you it was going to be 2 weeks. It was a hope, and I expect a better result this time around. And I'm going to instruct you now on the principles of law, which you should follow in considering your evidence and in reaching your verdict. It is your duty to follow all of the instructions, regardless of any opinion which you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved in the evidence. Consider only the evidence received during the trial and the law as given to you in these instructions, and from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written, formal accusation against the defendant, charging him with the commission of one or more criminal acts. You are not to consider it as evidence against him in any way, and it does not raise any inference of guilt. The information contains 4 counts of charged unlawful behavior against the defendant, and to each of these counts, he is under a plea of not guilty, which is a demand that the state prove every element of each charge beyond a reasonable doubt. Counts 1 and 2 of the information charge that between the 1st of August of 2020 and the 17th of May of the same year, at the city of Kenosha in this county, the defendant intentionally engaged in a course of conduct directed at a specific person, which caused that person and which would cause a reasonable person under the same circumstances to suffer serious emotional distress or to fear bodily injury or death to herself or himself or to a member of his or her family or household, and where the defendant knew or should have known that at least one of the acts that constituted the course of conduct caused the person to suffer serious emotional distress or place the other in a reasonable fear of bodily injury or death to himself or herself or a member of his or her family or household, and where the defendant's acts caused the other to suffer serious emotional distress or induce fear in the other of bodily injury or death to herself or himself or a member of his or her family or household. Stalking, as defined in the Criminal Code, is committed by one who intentionally engages in a course of conduct directed at a specific person, which causes that person to suffer serious emotional distress or to fear bodily injury or death to himself or herself or a member of his or her family or household. It did not come through. What I've got here didn't come through. What was sent to me?
No, the printed copy.
Remember, we gave you a printed copy that we
You wanna
thought.
look at it?
Apologize, but that.
It's just right on a 1284 is what it is.
I mean, it has specifically we wanted in the instruction. So it has the.
That I understand. This was the parties discussed and reached an agreement on this. So this is not from one side or the other.
So we know electronically it didn't work, Judge, but we were hoping that we thought the court was going to read the printed copy we
Well,
provided.
actually, I see now in the latter section, it does remove some of the paragraphs. Okay. Stalking, as defined in the Criminal Code, is committed by one who intentionally engages in a course of conduct directed at a specific person that causes that person to suffer serious emotional distress and that would cause a reasonable person to suffer serious emotional distress, and where the actor knew or should have known that the conduct would cause the person to suffer serious emotional distress. Before you may find the defendant guilty of either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. First, that the defendant intentionally engaged in a course of conduct directed at another. Intentionally requires that the defendant have acted with the purpose to engage in a course of conduct directed at the person alleged to be a victim. Course of conduct means a series of two or more acts carried out over time, however short or long, that show a continuity of purpose. Acts that you may find constitute a course of conduct are limited to: 1, maintaining a visual or physical proximity to the victim; 2nd, approaching or confronting the victim; 3rd, appearing at the victim's home or contacting the victim's neighbors; 4th, entering the property owned, leased, or occupied by the victim; 5th, photographing, videotaping, audio taping, or through any other electronic means, monitoring or recording the activities of the victim. This subdivision applies regardless of where the act occurs. And 6th, causing a person to engage in any of the acts described above. The second element is that the course of conduct would have caused a reasonable person to suffer serious emotional distress. Suffer serious emotional distress means to feel terrified, intimidated, threatened, harassed, or tormented. This does not require that the alleged victim have received treatment from a mental health professional. To determine whether this element is established, the standard is what effect the course of conduct would have had on a person of ordinary intelligence and prudence in the position of the alleged victim under the circumstances that existed at the time of the conduct. Third element is that the defendant's acts caused the alleged victim to suffer serious emotional distress. And the fourth element is that the defendant knew or should have known that at least one of the acts constituting the course of conduct would cause the alleged victim to suffer serious emotional distress. You cannot look into a person's mind to determine intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent and knowledge. If, as to the first or second count, you are satisfied beyond a reasonable doubt that all four elements of this offense have been proved, then you should find the defendant guilty on such count, either or both, or neither. If you are not so satisfied, then you must find the defendant not guilty on that count. The third count of the information charges that on or about the 17th of May of 2020, the defendant caused the death of Rosario Gutierrez Jr., with intent to kill him. Intentional homicide of the first degree, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the fatal act. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the fatal act. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something, while motive may be shown as a circumstance to aid in establishing the guilt of a defendant. The state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If, as to this third count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, then you should find the defendant guilty of intentional homicide of the first degree, as charged in the information. If you are not so satisfied, then you must find the defendant not guilty as to that count. The fourth count of the information charges that between the 17th of May and the 19th of May of 2020, at the city of Kenosha in this county, the defendant hid a corpse with the intent to avoid apprehension for a crime. The Criminal Code of Wisconsin is violated by one who hides or buries a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant hid a corpse. Second, that the defendant hid a corpse with intent to avoid apprehension, prosecution, or conviction for a crime. This requires that the defendant have acted with the purpose to avoid apprehension, prosecution, or conviction for a crime. If, as to this fourth count, you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty of hiding a corpse as charged in the information. If you are not so satisfied, then you must find the defendant not guilty as to that count. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless, in your deliberations, you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given. arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses both on direct and cross-examination, regardless of who called the witness. Second, the exhibits which have been received, whether or not they accompany you to the jury room. And third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at the trial. Disregard entirely any question to which I did not permit an answer. Do not guess at what the witness's answer might have been, and if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to the weight of that evidence. Weight of the evidence is decided by the jurors alone. You jurors are the sole judges of the credibility of the witnesses and of the weight of the evidence. During the trial, I have ordered certain testimony stricken, and you must disregard all such stricken testimony. You have heard testimony from a witness who may have, you have heard testimony from a witness who may receive concessions from the government in exchange for his promise of cooperation. This witness, like any other witness, may be prosecuted for testifying falsely. You should consider whether receiving concessions affected the testimony and give the testimony the weight you believe it is entitled to receive. Evidence has been presented regarding other conduct of the defendant for which he is not on trial. Specifically, evidence has been presented that the defendant was involved in growing and selling marijuana and growing and using psychedelic mushrooms. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait and that he acted in conformity with that trait or character with respect to the offenses now charged against him in this case. The evidence was received on the issue of witness credibility. You may consider this evidence only for the purpose which I have described, giving to it the weight which you determine it is entitled to receive. It is not to be used to conclude that the defendant is a bad person and for that reason that he is guilty of the offenses now charged against him. The testimony of a child should be weighed in the same manner as testimony of other witnesses. Considerations of age, intelligence, ability to observe and report correctly, ability to understand the questions and to answer them, sense of duty to speak the truth. Conduct on the witness stand, interest, appearance, and other matters varying upon credibility applied to a child witness in common with all the other witnesses. The district attorney and the attorney for the defendant have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. An exhibit becomes evidence only when it has been received by the court. Exhibits which may have been marked for identification and not received are not evidence. An exhibit once received is evidence whether or not it accompanies you to the jury room. It is not necessary that every fact have been proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find him guilty. Remarks of the attorneys are not evidence, and if their remarks suggest certain facts which are not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the lawyers, but their arguments, conclusions, and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under my instructions. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you should take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may testify only to facts. However, witnesses with specialized knowledge in particular fields may give opinions in those areas. In determining the weight you give to these opinions, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based, only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based upon those facts should not be given any weight. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors. Whether the witness has an interest or is disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had for observing and for knowing the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias, or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give to the testimony of each witness such weight as you believe it is entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and experience in your everyday lives. You decide for yourselves the reliability of things said to you by others, and you should do the same thing here. Evidence has been received that some of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. We are going to hear the closing remarks of the lawyers in the morning, and then I will give you about 5 more minutes of additional instruction, and then the case will be turned over to you. We will have 12 of you go into deliberation, and that'll be done by, there's a tumbler over there on the window ledge that you may recognize from your church, or not, but the names of all the jurors will be put in there. And if we need to get down to 12, then the defendant will draw out one of the names to be excused. 8:30 tomorrow. And any question, anybody? Even though the evidence is closed, you need to keep an open mind, and you've heard the arguments and those last few instructions. So please continue not discussing the case with anyone, not even fellow jurors. Don't read, watch, or listen to any account of the trial. And any questions? Have a wonderful evening, and we'll see you tomorrow. Anything further today?
No.
One way or another, we need to get I have to print instructions for the jury, so we need to clear this matter up somehow.
When we get over there, we'll try sending it to you.
Yeah, when they come over, and when I can see the pattern instruction numbers on them, they're always corrupt.
I'll copy and paste into a new Word document. We'll be that, and hopefully that will assist in this, but I will go make everything on that.
Thank you.
Don't be using somebody checking my state and don't think they're okay. Don't have to know see that I'm wrong. All right then. And then,